Hello everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty at iExamB. In this video, I have come up with another video from the same series, that is for SEBI Grade A Legal Officer Examination. I have picked the topic for discussion today, that is judicial review. It is going to be from constitutional law. It is also relevant in administrative law. This is a topic which is common between both. As we all know, administrative law and constitution are actually arising from the same source but now developed as a law. But we can study both of these laws together. So judicial review एक काफ़ी important topic है. We will discuss about it and then we will see some questions as well. So watch this video till the end. It is very helpful for your preparation. This video, all the videos of the series, I would suggest आप ये सारे videos को देखें. The reason that इसमें आपको एक comprehensive idea आ जाता है कि आपको किस तरीके से conceptual clarity की ज़रूरत है important topics में and किस तरीके के questions आप expect कर सकते हैं. Don't forget to subscribe to Legal B for all the videos. अगर आपने बाकी के videos miss किए हैं, do check it out in the playlist. कॉन्स्टिट्यूशन ऑफ इंडिया, इसमें से काफ़ी सारे टॉपिक्स हैं जहाँ से क्वेश्चंस रिपीटेडली आते हैं एंड इट इज़ हैविंग अ गुड वेटेज एज वेल. कॉन्स्टिट्यूशन का वेटेज भी काफ़ी अच्छा है, जैसे प्रियम्बल हो गया, देन प्रेसिडेंट हो गया, कुछ आर्टिकल्स जहाँ से द बैकवर्ड क्लासेस या ऐसे कोई कमीशन से रिलेटेड, कमीशंस लैंग्वेज से रिलेटेड, या फिर कुछ क्वेश्चंस ऑब्वियसली फंडामेंटल राइट्स, डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी. ये जो स्टार्टिंग के पार्ट्स हैं ये तो काफ़ी इंपॉर्टेंट है ही. एंड कुछ ऐसे कंसेप्ट्स और डॉक्ट्रिन्स है जो आपको ओवरऑल कॉन्स्टिट्यूशन में पता होना बहुत ज़रूरी है. एंड आउट ऑफ दैट आई एम टॉकिंग अबाउट जुडिशियल रिव्यू टुडे इन दिस वीडियो. We will understand it in detail and in some important MCQs also we will see within a very short period of time. जुडिशियल रिव्यू क्या है पहले ये समझते हैं. एज द वर्ड इटसेल्फ सजेस्ट, इट इज़ गोइंग टू बी कंडक्टेड by judiciary and that will be a review. Review means not something which is review jurisdiction but review of the actions that can be legislative, executive or judiciary. Both Supreme Court and High Courts are having this power as they are the constitutional courts, so they are having this particular power to carry out judicial review. This is to maintain the sanctity of constitution that judicial review has to be done. Constitution does what? It gives powers to all the bodies for their working. Constitution ने offices and bodies को create किया है and it has given powers to all the bodies. Respectively, powers have been divided. There is a division of power. We all know the theory of separation of power, but it is not in rigid or watertight compartments. Administrative authorities are also there, but sometime or the other all these authorities are swiping their places and sometimes they are entering into the domain of others. So at that time, if they are carrying out any activity and while doing that activity they are misusing their power or acting arbitrarily, then that has to be curtailed down. या फिर अगर वो अपनी ही ओरिजिनल पावर को एक्सरसाइज करते वक्त, यानी कि ओरिजिनल पावर इन द सेंस द वन with which they have been entrusted, as if executives are taking a policy decision or implementing any policy. So if they are doing that and they are doing it arbitrarily, then judicial review is going to come into picture to protect. As Supreme Court and the High Courts have been given this power of interpretation, they have to uphold the sanctity of constitution. Judicial review का यही objective है कि ये चेक करना है कि सारे लॉज कॉन्स्टिट्यूशन के हिसाब से हैं. नो लॉ इज अनकॉन्स्टिट्यूशनल. सो लेजिस्लेटिव, एडमिनिस्ट्रेटिव एंड जुडिशियल, ऑल दीज 3 एक्टिविटीज़ आर सब्जेक्टेड टू जुडिशियल रिव्यू. ऐसा नहीं है कि जुडिशियल डिसीजंस को जुडिशियल रिव्यू नहीं होता है. इट इज़ नॉट लाइक दैट. दैट इज़ ऑल्सो सब्जेक्टेड टू जुडिशियल रिव्यू. एडमिनिस्ट्रेटिव अथॉरिटीज़ इंक्लूडिंग एग्जीक्यूटिव्स, ऑब्वियसली. एडमिनिस्ट्रेटिव वर्ड काफ़ी ज़्यादा यूज़ होता है. द रीज़न you will understand if you study administrative law, the basic objective and administrative law actions, the actions of administrative authorities are very much subjected to judicial review and legislative authorities. So this is but obvious that all the 3 spheres are subjected to judicial review. What are the grounds? Let us see that on which judicial review can be carried out. Within these grounds only judicial review can be carried out, not for each and everything. नहीं तो क्या होगा, जो ओरिजिनल पावर दिया गया है बॉडीज़ को वो अफेक्ट हो जाएगा. बिकॉज Judiciary cannot enter into the domain of all these bodies until and unless one of these grounds is subjected to challenge. So there is a case law which is important over here. इसको आप note down भी कर सकते हैं. Civil Services Union versus Minister of Civil Service case. It is a famous case. In this case, grounds of judicial review were mentioned as if there is a jurisdictional error. अगर कोई jurisdictional error है, either there is lack of jurisdiction or there is excess of jurisdiction. ऐसा कोई एरर है, अगर ऐसा कोई एरर apparent है on the face of record, then immediately that can be curtailed down by judicial review. Irrationality. If the decision that is being taken is on irrationality, there is no particular reasoning, no proper reasoning for coming to that conclusion. इसके लिए एक टेस्ट अप्लाई किया जाता है, that is famously known as the Wednesbury test. ये आप एडमिनिस्ट्रेटिव लॉ में पढ़ेंगे, वेडनेसबरी टेस्ट, जो ये चेक करता है क्या वो डिसीजन रीजनेबली लिया गया है या इरैशनली लिया गया है, विदाउट एनी रीजनेबल नेक्सस. Procedural impropriety. If there is no proper procedure that has been followed, if suppose principles of natural justice have not been followed, notice has not been properly given, then that decision is accordingly subjected to judicial review. There is no proportionality. Means there has to be a balance between the actions that are being taken. If suppose a particular authority has punished a subordinate authority, so the decision that has been implemented or the punishment that has been inflicted, whether that punishment is reasonable in nature or it is in excess, that should not happen. So the proportion of that has to be checked out. That is known as proportionality. Legitimate expectation. Legitimate expectation is a doctrine, and according to this doctrine, if suppose a person is affected by certain actions but he is not getting a proper remedy in law because of that, but he is going to get certain legitimate expectations, the reason that he has suffered certain laws, this is actually a doctrine. So ऐसे टाइम पर जो action लिया जाता है by the respective authorities, that can be administrative many times, then again it will be subjected to judicial review. So these are the grounds in detail that need to be checked when a judicial review has to be carried out. According to Constitution, Article 13 is very, very important for recognizing judicial review. How it recognizes judicial review? All the laws that are inconsistent with or in derogation of the fundamental rights shall become void. This is very, very clear by Article 13. All laws that are in force in the territory of India, immediately before the commencement of this Constitution, they will become void. And the state shall not make any law which takes away or abridges the rights that are conferred by this part. That is also very true. State should not do such kind of activity because that will immediately become void. In this article, other than that, why this article is very important is that it is defining law. Law includes what? Any ordinance, order, bylaw, rule, regulation. So why this definition becomes important for judicial review purpose as well? Definition of law, because this is going to cover in the garb of law all such kind of decisions, not only judicial decisions, not only law by ordinance, order, bylaw, rules and regulations, but all the laws that are in force, laws that are made by legislature or implementation policies that are made by executive. Everything is going to be covered under this particular clause, that is 13 clause 3. And last clause is very much important, that is nothing in this article shall apply to any amendment of the Constitution made under Article 368 of the Constitution. ये भी एक important point है जो आपको ध्यान में रखना है कि Article 368 of the Constitution that provides for amendment of the Constitution, from that Article 13 has clause 4, which means that this is not going to apply and any law that is being made for amending the Constitution. It has been kept out of purview of Article 13. Constitution of India का syllabus काफ़ी important है, and it is vast also as compared to some other topics, and the number of questions are also going to be good in both the phases. You can see 10% weightage is there, and the syllabus is good in phase 1 also and phase 2 also, but again you have to focus on the important areas as the questions are asked from the very important and expected areas, so you can focus on that and score well in this subject. Let us see some questions. First, residuary powers of legislation rest with. Residuary powers of legislation is an important article that can be asked, you should remember the article number as well. And who can exercise residuary powers of legislation out of all the options that are mentioned? Of course, none other than Parliament can exercise it as per Article 248 of the Constitution. It is subjected to Article 246A. Parliament is having exclusive power to make any law with respect to any matter, and if that matter is not enumerated in the concurrent list or the state list, automatically it is not mentioned anywhere expressly, so Parliament will have the responsibility to make a law on that. That is known as residuary power of legislation. Next question, which article of the Constitution guarantees right to property? As this right to property is something which is very unique, amendment has been carried out. Earlier it was fundamental right. So ऐसे type के जो areas है यहाँ से आप questions expect कर सकते हैं. So be prepared on it. Article 300, 300A, 19(1), or whether it is not guaranteed at all now in Constitution, none of the above. So which article guarantees it? 300A. Remember that not only 300, 300A guarantees it. Persons are not to be deprived of property save by authority of law. That no person shall be deprived of his property save by authority of law. If there is an authority of law, then that is fine. But other than that, no person can be deprived of his property. ऐसा भी कुछ question आ सकता है, whether it is a fundamental right, whether it is a constitutional right, whether it is a legal right. So you have to remember that property is no longer a fundamental right. Next question, tribunals for adjudication of matters on foreign exchange shall be established by law made by appropriate legislature, parliament, cabinet, both appropriate legislature and the parliament, all appropriate legislature, parliament as well as the cabinet. All these people will be involved. Now this question is also interesting. Administrative tribunals के बारे में बात कर रहा है ये. Tribunals for adjudication of matters on foreign exchange, appropriate legislature. सो अगर एडमिनिस्ट्रेटिव ट्रिब्यूनल्स की हम बात करें तो 323A एप्लीकेबल होगा. इसमें से क्वेश्चन भी आया है पहले सेबी में. एंड नाउ 323B इज टॉकिंग अबाउट द अदर मैटर्स. सो अदर मैटर्स कैन इंक्लूड एडजुडिकेशन ऑफ मैटर्स ऑन फॉरेन एक्सचेंज एज वेल. अगर यहाँ पर एडमिनिस्ट्रेटिव नेचर का कोई डिस्प्यूट होता तो 323A एप्लीकेबल होता. सो appropriate legislature may by law provide for adjudication or trial by tribunals of any disputes, complaints or offences with respect to all or any of the matters that are specified in clause 2. So you can check what all things are covered under clause 2, that is relating to tax, that is relating to foreign exchange, import, export across the frontiers, industrial and labor disputes. So this you have to remember that all these matters can be heard by tribunals, and this is guaranteed under Article 323B of the Constitution. Which clause of Article 368 mentions its correlation with 13? See, what we have seen today is 13 mentions correlation with 368 under clause 4. But what about 368? Is there any clause that mentions correlation of 13 with that article? We have seen vice versa recently in this video. But what about Article 368? Yes, there is a similar provision in 368 also, which correlates it with 13, that both will not be affected, of course, by each other. That is clause 3. Nothing in this article, nothing in Article 13 shall apply to any amendment that is made under this article, that is Article 368 of the Constitution. So both the articles are having this provision. This has been added by amendment to the Constitution. The last question for today's discussion, power of the Parliament to legislate on matters in state list in the national interest is provided under. Now see, the matter is enumerated in the state list, so it is a state subject. But since there is national interest involved, Parliament shall have power for this. So where it is going to be mentioned? Concurrent list, emergency provisions, 7th schedule, Article 249, Article 250. You just have to select the correct provision. Do this 7th schedule, all the lists and these articles well, as we can find questions from this as well. So power is going to rest with the Parliament. That is true if it is in national interest, even though the subject is in state list. But which article provides for it? Article 249 specifically provides for power of Parliament to legislate with respect to a matter in the state list in the national interest. So this was all that I had to discuss with you in this video for Constitution. The subject is very vast, but if you study it in the right manner, you can score really well from this topic also for SEBI Grade A Legal Officer examination. Don't forget to subscribe to our YouTube channel and get all such kind of beneficial videos and prepare 50% faster with iExamB. Thank you.